Hello, this is Sherrod Seward with Queen City Immigration Law's Combat Sports Practice. Today we're going to talk about a major issue and a common issue that comes from managers and promoters. What do I do with my fighter that doesn't have a valid visa? Whether it's because they had a B visa and they just let it expire and never change status, or if they had a P visa but didn't get it renewed in time. Well, the normal way that it would go is that you'd have to apply for another P visa, but you can't change status while they're United States because they don't have a valid visa to exchange the status from. So therefore, they'll have to apply for a visa to pick it up at any consular office outside the United States. Now, when they go pick up the visa, they'll deem them inadmissible. And what we do is we'll give them a 212 D3 waiver to present at the time that they do the interview. From there, the consular officer will take some time to look at the package, make sure that they don't have any criminal history. They'll look at things such as like what's the magnitude of the reason that they're coming to the United States. So of course, if it's a big fight, that's positive. And of course, if they have no criminal history, that's also pretty important. When you do it this method, you can expect to have to wait about a month to 2 months, depending on where you are, to come back in the country. And sometimes it can be convenient. For example, we've had a promoter want to do a fight in Canada for the fighter where he can get into no problem. So what we said is, okay, have him come in a little early, do his fight. We'll have a visa waiting for him at the consular office. He can present his waiver, stay in Canada for a little bit until it's ready to get picked up. Now, one thing is we'll find that fighters obviously are scared about leaving the United States with no valid P visa to pick it up, because there's always a chance that they will not be allowed back in to the United States even though they have their approved P visa. In that case, we're talking to promoters and managers about actually still applying for a P visa for consular processing, even if the fighter doesn't pick it up. Because what happens is if they happen to get picked up while they're in the United States without that expiration, they're going to get held in a prison or maybe some detention center. If they already have an approved P visa, it's a lot easier argument to go to the immigration judge and say like, hey, they already have an approved petition, you might as well let them out so they can go see that process through. And from there, since they already have the approved petition before they're in removal proceedings, that will help them get out of that ICE bond so they can still adjudicate their case without having to stay in a detention center. So the basic 2 points of this conversation is, one, if you have an expired visa, the proper way to do it is to apply for the visa to pick up overseas at any consular office. You present a waiver, which we can help you prepare, and you'll have to wait 1 to 2 months to get back into the country. Or even if they don't want to leave the country, at least still apply for the visa so you can have an approved application to help argue to get out of detention in case that there is a bond holding or a deportation that's put in place. Again, this is Sherrod Seward, Queen City Immigration Law, Combat Sports Practice. Don't hesitate to contact us about any combat sports related immigration issues. Thank you.